What I was trying to explain is it's extremely complex from both a legal analysis standpoint as well as a legal procedural standpoint.
Okay.
And the reason for that is because this is a very abstract agreement or obtuse agreement, whatever you want to use. In short, I've never seen a agreement where you're trading owner, builder, building material or building stuff for right to possession. Okay, and
Always something new.
No, but that's not a good thing. It's not a good thing. Reinventing the wheel in this situation is not a good thing. You don't want to go into unlawful detainer court, which is a court that's basically only focused on did you pay your rent and do you have a right to possession in this case, with a new novel thing that Joe Blow and Mary decided up in Anaheim. And then the court has to figure it out now and unwind it because Joe Blow and Mary are no longer getting along. So no, it's not a good thing. So from a legal analysis perspective, why it's complex is because it's a novel situation with regard to the agreement. I've never seen anything like this. Who knows? A judge, like an unlawful detainer judge, has like thousands of cases a year. So maybe she's seen something like this, but it's very weird. It's a weird one. So trying to figure out what the judge is going to do with it then makes it very difficult from an attorney's representation standpoint of what to do, because I've never seen a thing like that. So the only thing I can defer to is other case law and situations that I've seen that potentially apply to this situation. And one of the things that keeps coming back up is, because I think per the contract, he's probably entitled to right to possession, right? But again, he's arguably moved out of there because possession is probably for the building, not necessarily the back area where he's gone or moved to since they had the falling out. Mm-hmm. The agreement doesn't really specify if he was entitled to sole possession or they were going to be splitting it the entire time. There's a lot. I can keep going and going. We've talked for hours about all the different reasons that makes it hard to analyze because there's so many issues there. Okay, so there's a lot there, and it's a unique situation which makes it difficult. From a procedural standpoint, okay, not only are we dealing with this issue with three different forms now, or two different forms now. Well, the mediation is kind of a third, but it's kind of off the table right now, or couched. So, assuming we get past these two, and he's entitled to stay where he's at, right?
Yes.
I think the only way then we get actual performance of the contract, which is basically for possession of the area where she's in,
yes,
is by another, because it's probably not going to resolve the mediation. After mediation, if something doesn't resolve in mediation, it goes to litigation. Mm-hmm. That means another case for breach of civil contract in unlimited jurisdiction court. We can request possession there as well, but you'd only get one or the other. Either the money back, what the judge feels is reasonable compensation for the loan, whatever, and or possession. Either or possession. He wants possession, right? And this brief is about his right to possession that you guys wrote. Is that in 99? So in order to get a judge to order possession, in order for that to happen, you either sue for money damages in court, or in this situation, you could sue for what's called specific performance, which would be possession of the property. Okay, specific performance is a disfavored remedy under the law because. In short, if there's an easy way to if the judge thinks there's an easier way to fix this by doing money, I'm doing that instead of possession. And I gave him an example of a corn farmer that sold his corn as feed to a dairy farmer. If they found out that he was selling to somebody else and tried to sue to stop it, no, I need that corn, the judge would probably say, nah, we're going to give you go get your corn somewhere else and come back for money damages later. That's just how the law looks at things. It goes for the easiest remedy for the judge to make that is not going to result in duplicitous litigation, da-da-da-da-da-da. And I think that happens here because in order to get possession, we would need to get that court order that says he's entitled to it and then do another unlawful detainer case. So from that, like, legally, there's all those issues. And I don't even think and one of the issues I meant to talk about is the unlicensed contractor issue. How this is arguably, on one end, this is arguably a loan that he's entitled to reasonable compensation on, and blah, blah. On another end, there's a potential that the court finds that he's an unlicensed contractor and he's entitled to absolutely nothing, not even the money he put into materials in the property. Because the law in California is that if I entered into agreement with you, me as an attorney, entered an agreement with you, and you randomly, or him, and he built that beautiful house in Newport Beach, literally from the sand to a mansion. And I knowingly said I'm going to get him because he likes doing work. I've already seen it in the wall drop case, and I bet you, and he likes me. I'll be able to convince him that I'm going to pay him, even though I've told him about unlicensed contractors are going to. He goes and builds me a mansion, and I, in good faith, in bad faith, have him build it for me. The court is required to give me the mansion for free in that situation. No matter how unfair or how insane that sounds, that's the law in California. I've seen cases where a rich guy knowingly has a friend do something on his house, build a $500,000 thing, builds it beautifully, and then fucks over his friend. And then when they go to court, it's the factual record is undisputed that, yep, he knew he was unlicensed. He knew about the law regarding unlicensed, and they still did it. He purposely did it to screw him over. It's still the bad guy that screwed the good guy over, because in California they view unlicensed contracting so strong. So I'll let you ask questions, but I just want to complete the thought. So there's so many legal issues that really want me to focus on what I think the best angle of this case is, as well as the procedural issues, make me really, really want to boil this case down. And I think that boils down to he needs to get the hell out of there, and we need to chase the money. Is really my feeling on this case. It's what I've been trying to get him on board with for about 10 days. I don't even know how long now. But I understand.